Good evening and welcome to the Institute of Advanced Legal Studies. Thank you for coming to this evening seminar. I'm Diamond Ashiagbo and I'm Professor of Law here at the Institute and Director of Research. I'm delighted to be introducing one of our visiting fellows at the Institute, Dr. Natasa Mavronicola, who will be speaking on Reading Human Rights Morally, Uncertainty and Restlessness at the European Court of Human Rights. Dr. Mavronicola is Senior Lecturer in Law at University of Birmingham School of Law. She researches and teaches on human rights, public law, legal theory, as well as the interplay between counter-terrorism and human rights. She also currently serves as Special Advisor to the United Nations Special Rapporteur on Torture, and has previously provided expert input to the Commissioner for Human Rights at the Council of Europe and the European Network of National Human Rights Institutes. She's written widely in those areas and is actually particularly busy this year, although she's technically on sabbatical, because she is a visiting fellow at this institute, as well as during the year a visitor at the Faculty of Law, University of Cambridge, and also a research visitor to the Bonavera Institute of Human Rights at the University of Oxford. Prior to moving to Birmingham, Dr. Mavronicola was lecturer in law at Queen's University Belfast and a teaching fellow at University College London, where she, I hope you don't mind me saying so, did her undergraduate law degree and obtained the highest first that year, including the faculty's Andrews Medal, and I know because I was one of Natasha's tutors. It was EU law, wasn't it, at UCL, and so we knew then that Natasha was destined for great things in terms of legal scholarship, and she went on to complete her BCL at Oxford and her PhD at the University of Cambridge in 2014, including spending a few months as a visiting doctoral researcher at Harvard Law School. So as I said, she works in the area of public law, legal theory, human rights and counter-terrorism, and tonight's seminar topic could not be more topical, in that I was just reading, in fact, prompted by Natasha's tweets, that today the European Court of Human Rights has handed down judgment in a case which some people know as that of the Hooded Men, which was from the 1970s, the UK authorities accused of using techniques which allegedly amounted to torture against members of the Irish Republican Army, and the question was whether these 5 techniques against the Hooded Men were torture. And so I don't know whether Natasha will include that in her analysis of the restlessness of the European Court of Human Rights on its moral or otherwise reading of human rights. So thank you, Natasha.
Thank you, Diamond, and thank you everyone for being here on a Tuesday evening and also following a prolonged period of strikes for many people. As someone from a so far non-striking university, I just wanted to thank and express my solidarity with all of those striking. I also want to thank the Institute of Advanced Legal Studies for hosting me during this academic year and for allowing me to take advantage of a fantastic array of resources, as well as the opportunities to discuss various legal issues with a brilliant set of scholars, including all of you today. And I especially want to thank Professor Diamond Ashiagbo for being a source of support and wisdom ever since she taught me EU law in my undergraduate years at UCL, which I don't want to say how far back it was, but I think you can gather. And maybe to thank her a little bit less for presenting me as somebody who has actually anything particularly useful to say. But while I'm enormously indebted to her and many others for guidance, advice, and fruitful conversations for the qualities, if any, of what I'm about to share with you, all the shortcomings of these thoughts in progress remain entirely the product of my own shortcomings. So in the next 40 or so minutes, I want to sketch out some concerns and thoughts that speak to the significance of both certainty or uncertainty and restlessness in the European Court of Human Rights interpretation of human rights as particular moral wrongs. And I do so on the premise that, as George Letzes wrote in 2010, and subsequently the European Court of Human Rights in its interpretive ethic has favored the moral reading of convention rights. So this sketch that I'm offering forms the starting point of a project on which I hope you can provide lots of food for thought for. I want to start and actually take up most of your time by thinking through the significance of certainty in the interpretation of the European Convention on Human Rights by the European Court of Human Rights. I've been coming and returning to certainty throughout much of my academic research so far on European Court of Human Rights doctrine. I've been preoccupied with European Court of Human Rights doctrine for a few years now, and I've focused more particularly on the way the court has interpreted what it has tended to refer to as particularly fundamental rights. Notably, Article 2 and Article 3 of the European Convention on Human Rights, which are the right to life and the right not to be subjected to torture or to inhuman or degrading treatment or punishment, respectively, although it would be remiss, of course, not to count at least Article 4 of the European Convention on Human Rights also within this short list. The focus of my PhD was Article 3 of the European Convention on Human Rights, and this provides that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. And this pithy provision has had remarkable and evolving implications in domains ranging from counterterrorism and police violence to sentencing and imprisonment to immigration and healthcare. At the same time, the European Court of Human Rights interpretation of this particular right, and notably its inconvenient or politically inopportune implications for contracting states, have been the target of increasing indignation from at least some corners. And this indignation has often been framed as concern about the mission creep of the Convention or particular provisions of the Convention and the Strasbourg Court. Now, apologies for the autobiographical note, but I think it offers, again, a little bit more background for explaining some of what follows. I've spent a considerable portion of my research defending as well as explaining the absolute character of Article 3 of the European Convention, and also the counter-majoritarian bite of many of its instantiations, notably those that protect some of the most unpopular persons within contracting states' jurisdictions, such as irregular migrants, and I count refugees and asylum seekers within this broad umbrella, terrorist suspects and prisoners, just to give a few examples. But back to certainty. Writing in 2012 on what is an absolute right, I suggested that it is a right which is non-displaceable by considerations extraneous to it. In the case law of the European Court of Human Rights, Article 3's absolute character entails that it is free from qualification, any sort of inbuilt qualification in the style of, let's say, Article 8, the right to private and family life, which allows for interference when necessary in a democratic society. It is also non-derogable, so there's no derogation allowed even in times of war or other public emergency threatening the life of the nation. And it protects everyone unconditionally, irrespective of perhaps particularly unmeritorious behavior. But this means that the content of the right takes center stage, and its interpretation, or as I put it, writing in 2012, its specification, delimits the scope of what is conclusively unlawful. In light of this, I probed the European Court of Human Rights specification of Article 3. And I suggested that a key problem with the case law providing for the specification was a tendency by the European Court of Human Rights to make an all things considered kind of ex post facto assessment that at times seemed to provide very little ex ante guidance. I returned to my concerns about certainty, writing more recently on the uncertainty and incoherence surrounding duties to criminalize and prosecute under the right to life in European Court of Human Rights doctrine. And today, before speaking to you, I was, as Diamond mentioned, looking and also tweeting about the European Court of Human Rights' refusal to revise its 1978 judgment in Ireland and the UK. A refusal which featured an appeal by the majority in their ruling, an appeal to legal certainty. This concern with certainty is, of course, by no means solely my pet project. It's not solely my concern. And in the context of the European Convention and the European Court of Human Rights, it has played a substantial part in ongoing debates on the interpretive methods and outcomes in the European Court's interpretation and concrete specification of Convention rights. More specifically, the uncertainty which allegedly characterizes European Court of Human Rights doctrine has been an increasingly prominent target of detractors of the court's interpretation of convention rights. In his recent pamphlet commissioned by Policy Exchange, home of the Judicial Power Project, Noel Malcolm described the European Court of Human Rights doctrine as an unclear, indeterminate, subjective, and unpredictable system of human rights adjudication, which, I continue to quote, can barely meet some of the most basic requirements of the rule of law. He noted in scathing tone, I imagine, that, and I quote, it was the European Court itself that defined certainty and foreseeability as two of those requirements, so two requirements of the rule of law. And he's not alone. Lord Sumption, for example, considering chiefly the living instrument approach of the European Court of Human Rights, which approaches the Convention as capable of having an evolving interpretation, attacked what he labeled the power to extrapolate or extend by analogy the scope of a written instrument so as to enlarge its subject matter, which Lord Sumption considered to be exercised by the European Court of Human Rights, and suggested that it can't be reconciled easily with the rule of law. He argued that while there are particular reasons for insisting on the requirement of certainty in the criminal law, the same principle must surely apply to all law, albeit within broader limits. On the other hand, and notably in defense of the European Court of Human Rights living instrument approach, George Letsas has repeatedly discounted the significance of certainty in the human rights context. In a theory of interpretation of the European Convention on Human Rights, he argued that it is generally thought wrong to hold people accountable for violating standards that they could not possibly know they were bound by. On this view, the idea of protecting people's expectations calls for both certainty and stability in the interpretation of the law. The application of this idea to international law, he continues, would still appear problematic, as it is hard to see why surprising contracting states is morally wrong. Responding more recently to Lord Sumption, Letsas provided a nuanced account of the relevance of certainty in the context of human rights, which I hope you won't mind if I quote almost in full. He says, the idea that the European Convention on Human Rights is a living instrument often comes with a degree of surprise. The Strasbourg Court may recognize as a human rights issue something that some or most states never expected. But is the legal value of certainty paramount? We think that it is paramount only in some areas of law, such as criminal law, where it is unfair to defeat the expectations of individuals about when the state will use its coercive force. But no individual's life plans, he says, are upset when the Strasbourg Court unexpectedly upholds new human rights claims, such as trafficking or prisoners' rights. The only one who might be surprised and adversely affected by such holdings is the state which is held responsible for the human rights violation. And the value of certainty, he continues, is meant to protect individuals from arbitrary interference by the state, not to protect the state from being scrutinized about its intrusion on individual rights. So he concludes, so the value of certainty, important as it may be, cannot carry the weight of a conclusive attack on the living instrument approach. What to make of this disagreement? First, it is true that certainty, understood as clarity and predictability, tends to be seen as an essential aspect of the rule of law. We may refer to Lord Bingham's first rule of law principle, which I think he took to be a sine qua non of any coherent understanding of the rule of law. He said, the law must be accessible and so far as possible intelligible, clear, and predictable. This seems obvious, he thought. If everyone is bound by the law, they must be able without undue difficulty to find out what it is, even if that means taking advice, as it usually will, and the answer when given should be sufficiently clear that a course of action can be based on it. Importantly, for our purposes today, such an understanding of the rule of law is shared by the European Court of Human Rights itself. As alluded to by Noel Malcolm, the European Court of Human Rights has indicated that The law must be adequately accessible. The citizen must be able to have an indication that is adequate in the circumstances of the legal rules applicable to a given case. The court also said a norm cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able, if need be with appropriate advice, to foresee, to a degree that is reasonable in the circumstances, the consequences which a given action may entail. The European Court of Human Rights has stipulated this idea in judgments also against the United Kingdom, such as Gillen and Quinton against the UK concerning suspicionless stop-and-search powers. So indeed, we might say, as the court does, that a degree of certainty goes to the heart of law itself. It goes to the heart of law insofar as law is understood as notifying individuals of how they might stand to be impacted upon by acting or not acting in particular ways, but also guiding and coordinating people's interactions with each other or with the state apparatus, and directing, but also indeed limiting decision makers who make decisions impacting on individuals. The guiding and limiting function of the law is especially important when the implications of falling foul of the law are coercive. That is fundamentally tied to autonomy and the idea that to be held accountable and to face detriment for failing to comply with the law, you must be able to know with a degree of certainty what the law demands of you. This is also tied to the principle of no punishment without law, which is enshrined as a right in Article 7 of the European Convention on Human Rights. It is worth noting also that certainty pertains to process and reasoning in the application of the law and in building substantive pronouncements of the law, as well as in those substantive pronouncements themselves, so the outcomes of processes and reasoning about law. And this becomes quite important about adjudication. Note the centrality, however, after all of what I've said, of individuals to the value of legal certainty, in the idea that the law is meant to notify, guide, and coordinate individuals' acts, and also that it's meant to guide and limit public authorities, public bodies, taking action which impacts on individuals potentially in a detrimental fashion. It's precisely in light of the centrality of the person to the significance of legal certainty that Sumption, Letzes, and many others would agree that the value of legal certainty is amplified in the context of straightforwardly coercive law, notably the criminal law, because that is the area of law, in at least our predominant conceptions of municipal law, where individuals stand to lose the most. So, in light of this, what is the value of certainty in supranational human rights adjudication, and notably in the European Court of Human Rights adjudication? The idea that surprising contracting states is not hugely problematic, particularly in the context of human rights law, carries considerable force, in my view. It is the persons who navigate and are subject to law that are to be safeguarded through legal certainty, but the centrality of the person in realizing the value of certainty is further buttressed and amplified in the human rights context by what the human rights project and by what human rights are about. One could allude to the significance of human dignity, which the European Court of Human Rights stipulates or proclaims is central to the European Convention on Human Rights, and to which leading commentators such as Christopher McCrudden attribute at least a core understanding, which includes the principle that the state should be seen to exist for the sake of the individual human being, and not vice versa. But we need not appeal, I think, to such lofty principle to recognize that human rights are first and foremost about protecting people and not states. Nonetheless, even if we take this as our starting point, which I do, that individuals are central to the significance of certainty, especially in the area of human rights law, the idea that surprising contracting states is immorally wrong doesn't end the story. We cannot entirely discount or disregard certainty in supranational human rights adjudication for various reasons, and I will outline just a few. The first is that human rights bind states, but concern and affect individuals. Knowing what human rights and correlative state obligations flow from the Convention is significant for those who need to assert their rights. Being able to point to clear statements of principle from the European Court of Human Rights that addresses one's issue can be crucial to a person wishing to vindicate their Convention rights effectively in what are often time-sensitive and otherwise pressing circumstances. One example might be in the context of facing the possibility of being expelled to a state where you face a real risk of ill treatment, contrary to Article 3 of the European Convention on Human Rights. It's important for those purposes to know what kind of ill treatment is caught by Article 3. More generally, guidance is also important insofar as we are talking about a system that concerns and affects individuals, for the effectiveness of such a system, for the effectiveness of the Convention system. Again, this speaks to the protection of the persons who are meant to enjoy the rights provided for in the Convention. A prominent current concern is the European Court of Human Rights substantial caseload, and a recurring, though not necessarily dominant, theme as to how this caseload is to be alleviated is the importance of having some guidance-orientated pronouncements that are also coherent by the European Court of Human Rights. More generally, certainty as to what the Convention demands by the norm appliers is also important in securing compliance. The second element or issue attesting to the significance of certainty in European Court of Human Rights doctrine is that human rights in general, and Convention rights in particular, tend to be especially, though not uniquely, general abstract legal standards, which require deliberative processes of, again, I will say, specification to arrive at individual outcomes. But also, as I think is needed, to distill guidance-orientated norms. The court itself has indicated that its judgments, in fact, serve not only to decide those cases brought before the court, but more generally to elucidate, safeguard, and develop the rules instituted by the Convention, thereby contributing to the observance by the states of the engagements undertaken by them as contracting states, a point that speaks to compliance, as I mentioned previously. And this kind of layering of specification that occurs, hopefully creating some guidance-orientated norms, is important to acknowledge. To give an example of the layers of specification involved, again, I will go into my comfort zone and look at Article 3. No one shall be subjected to torture or to inhuman or degrading treatment or punishment is this kind of abstract, general legal standard. And it has undergone a process of specification whereby one of many intermediate guidance-orientated principles that have been distilled or specified from it is the principle that, and I quote, "In respect of a person who is deprived of his liberty, or more generally is confronted with law enforcement officers, any recourse to physical force which has not been made strictly necessary by his own conduct diminishes human dignity and is in principle an infringement of the rights set forth in Article 3 of the European Convention on Human Rights." This has resulted in a range of concrete outcomes in an array of case law, including, for example, violence against peaceful demonstrators. An example of one particularly contested outcome of the application of this intermediate principle has been the finding in the Grand Chamber judgment of Bouillyde against Belgium that single slaps inflicted by a police officer on two powerless persons in police custody violated Article 3 of the European Convention on Human Rights. I mentioned this last case just to also point to the fact that this specification process is a site of contestation. Bouillyde, for example, attracted a very strongly worded dissent, which I won't dwell on, but I'm happy to discuss later. Now, the fact that this specification process is a site of contestation was rather strikingly made clear in Lord Hoffman's 2009 Judicial Studies Board annual lecture on the universality of human rights, where he argued that, at the level of abstraction, human rights may be universal, but, he continued, at the level of application, the messy detail of concrete problems, the human rights which these abstractions have generated are national. Their application requires trade-offs and compromises, exercises of judgment which can be made only in the context of a given society and its legal system. Now, for what it's worth, I think Lord Hoffman overplays the nation-specific character of a lot of human rights problems and the resultant need across the board for nation-specific solutions. But I do think that his comment brings into sharper relief the significance of and the contention surrounding the way in which provisions whose demands on paper are abstract and uncertain are specified into more concrete and arguably certain norms and outcomes. The reasoning by which this happens, I think, is as crucial as the outcome. My third point regarding certainty significance concerns the need to have at least some red lines. The specification of red lines and the reasoning that shapes these red lines can be crucial in protecting people, I think, not least because red lines can be evoked to counter manipulative interpretive maneuvers which specify desired acts or past antics as falling outside the scope of certain rights. Now, we need not look very far for such maneuvers, as the torture memos have been in the news again recently. The torture memos were the documents that provided legal license for waterboarding and other forms of torture, and which have now resurfaced as front-page news in light of Gina Haspel's appointment as director of the CIA. Interpretive maneuvers motivated by bad faith loom large, in my view, particularly in times of actual or perceived or manufactured crisis. You may be surprised or not surprised to hear that I'm not idealistic enough to think that the Strasbourg court's red lines will ultimately prevent any blatant abuses of sheer power. But they might nonetheless militate against the legal facilitation or absolution of such abuses. To cement the global significance of such red lines and of European Court of Human Rights doctrine in this regard, which can be both positive and negative, I would mention for the day that's in it that the now 40-year-old judgment in Ireland and the UK, whose revision was rejected today, has the dreadful legacy of informing those torture memos that facilitated the torture conducted by the CIA post 9/11. So red lines and also how they are set matter. And as a fourth and final point, I would highlight that certainty in human rights doctrine matters because although the immediate duty bearers, at least in the context of the European Convention on Human Rights, are states, human rights doctrine is capable of having significant coercive implications. The former and formidable European Court of Human Rights Judge Françoise Tolkens wrote in 2011 of a paradox, insofar as human rights have the capacity both to neutralize and to trigger criminal law and criminal law enforcement. And Yoram Lazarus warned in 2012 of how positive obligations under the European Convention on Human Rights actually often amounted to duties to coerce and not just to protect. My research has focused especially on the coercive dimension of positive obligations doctrine in relation to the right to life and the right not to be subjected to torture or to inhuman or degrading treatment or punishment. Close examination of European Court of Human Rights doctrine elicits explicit demands by the European Court of Human Rights, not only for the protection of these human rights through the criminal law, but for the specific pursuit of criminal redress and indeed appropriate penalties, commensurate penalties, for particular violations of these rights in particular cases. One example being the famous or infamous, depending on where you're standing, judgment in Gefgen against Germany. Now, that the European Court of Human Rights makes these demands as to the deployment of the criminal law is also increasingly arising in relation to Article 4 of the European Convention on Human Rights, not least in relation to human trafficking, which, I may remind you, George Letsa cites as being an area in which surprising developments are unproblematic. This amplifies the significance of certainty in these areas, as well as calling into question the appropriateness of the European Court of Human Rights coercive duties doctrine. So just to concretize this issue a little bit further, I want to refer you briefly to the right to life dimension of the coercive duties doctrine, where my recent research on this topic revealed three things. First, that the European Court of Human Rights has increasingly focused on the criminal law and criminal redress, often being responsive to applications to it, as being central in the state's positive duties to protect life. And it has focused on such duties to the point of bordering on what Leora Lazarus labels coercive overreach, by aligning breaches of the negative obligation under the right to life with positive duties to immediately provide for individual criminal liability for such breaches. Second, this coercive overreach has simultaneously driven the European Court of Human Rights to dilute the negative obligation under the right to life, whereby the very strict standard that life is not to be taken except where this is absolutely necessary has been reduced to a more subjective, criminal-style standard of culpability. And third, that in light of these two preliminary points, these two previous points, the doctrine is characterized by incoherence between high principle about the stringency of the negative obligation and also the non-criminal role of the court and the application of these principles in concrete cases. But it's also been characterized by uncertainty regarding the precise circumstances in which the European Court demands criminalization and the pursuit of criminal redress mechanisms in relation to the taking of life. In my view, this concretizes the significance of this area of the doctrine and highlights that it is important to confront any uncertainty and incoherence that might characterize it and the reasoning that makes it up. This last point then, this fourth point on the significance of certainty, raises a slightly distinct argument perhaps from the previous ones. The argument that legal certainty is important not just to protect victims of human rights violations, but also in protecting suspected individual perpetrators of human rights violations who may face penal repercussions via the European Convention on Human Rights and the European Court of Human Rights. It also strikes, I think, a general note of caution regarding the coercive edge of the European Court's doctrine. So, there are good reasons, I think, to care about certainty in European Court of Human Rights doctrine. And, these reasons are, in my view, premised on and orientated towards protecting people and protecting people's human rights. Certainty is significant for the realization of human rights and the protection of persons. We need it so that people know their rights, so that lines are drawn as a bulwark against abuse or bad faith interpretations by norm appliers. We need it so that norm appliers are guided towards compliance. And we need it so that it drives clarity and caution in the context of human rights coercive obligations. But to repeat, the realization of the value of certainty in supranational human rights adjudication is underpinned by the centrality of the person and protecting people's human rights. And the significance of certainty is also qualified by this centrality of the person. As I indicated at the start of my talk, the European Court of Human Rights is engaged in a perennially flawed attempt to interpret and apply certain wrongs prescribed in abstract terms in the European Convention on Human Rights. And, I might add, the Court is doing so in the context of uncertainty and disagreement regarding these rights' substantive scope. While the Court has a duty to guide and to provide a coherent interpretation of these wrongs, this is a duty that is shaped by its overarching task to deliberate on these carefully and, I believe, restlessly. In the context of uncertainty about the character and scope of these wrongs, the European Court of Human Rights should interpret rights with the opposite of complacency. That is, with the ready awareness that it may well be getting rights wrong. To this extent, I think Letzes is right, that an appeal to certainty cannot conclusively bar the prospect of the evolving interpretation of the European Convention on Human Rights. The uncertain character of the wrongs at issue, but also the court's fallibility, compel restlessness. That is, the capacity for the interpretation of the Convention rights to remain open to new and improved understandings of the wrongs at issue. The capacity for evolution, in other words. Now, these new and improved understandings, I think, can be arrived at by heeding relevant input on the wrongs at issue. Often the European Court of Human Rights pays particular attention to the reasoned conclusions, for example, of bodies tasked with giving more concrete meaning to the overarching norms it is interpreting. In the case of Article 3, to return to my home turf again, for example, this has often meant for the court that it has regard to instruments such as findings of the Committee for the Prevention of Torture, or the European Prison Rules, or the United Nations Standard Minimum Rules for the treatment of prisoners. And the European Court of Human Rights gets a great deal of insight by foregrounding the lived experience, when it does, of practices which come before it, and by paying attention to reasoning and to findings which have foregrounded those who are marginalized or who otherwise find themselves at the fringes or falling through the cracks of the grand European promise of human rights, democracy, and the rule of law, those who have their rights violated day in, day out. So, how to best pursue certainty, which we take to have some value in supranational human rights adjudication, in the context of uncertainty and, in my view, warranted restlessness about what human rights demand in particular situations, but also more generally. Reflecting back on the qualified value of certainty in this context, I would suggest that the European Court of Human Rights can best pursue certainty by offering transparent deliberation on the Convention rights through, as far as it can, relevant reasoning, loaded terms here, by seeking to distill principles out of these processes that are capable of offering ex-ante guidance and not merely relying on some sort of abrupt conclusion in light of the facts. And just to be nice to the court, I think that it has increasingly been doing this under various types of headings, for example, recapitulation of general principles and so on. Also, by employing caution and particular attention to certainty with regard to obligations that have actual coercive implications. And finally, in my view, this is where I'm sort of only dipping into something in this project, by adopting an approach that is characterized both by the pursuit of a coherent reading of the Convention's demands and a readiness to reimagine what would be a coherent reading of the Convention's demands. This entails deliberation and reflection which pays attention to the relevant particulars but does not let go of the more general fundamentals, which attempts to reason in a principled manner and is transparent as to the decisive factors leading to the outcome in a particular case, so that the reasoning is open to critique and even constructive dialogue. And deliberation and reflection which operates with a continued profound awareness of its all too human fallibility, and also with the anchor of its approach being the protection of the person. So just to suggest some ways in which the European Court of Human Rights will need to employ restlessness, and does often employ restlessness in the case law, in terms of how it assesses particular situations, and how it applies overarching norms or specifications of these norms to such situations. The European Court of Human Rights can, for example, and is often open to input that illuminates a previously unseen or too readily disregarded element in a particular situation. This can happen most clearly where the court is put in a position where it can better grapple with how certain acts or legal requirements or obstacles hurt and indeed wrong certain persons. One example in which the European Court of Human Rights stance has evolved in light of paying attention to relevant sort of new knowledge about the debilitating elements of a particular experience has regarded the debilitating experience of solitary confinement, which has led the court to delimit its application, to delimit the application of solitary confinement in its Article 3 case law very stringently. And in this process, the European Court of Human Rights has paid attention to the deliberations and outcomes of various expert bodies, which are informed ultimately by a growing understanding of the wrong of placing someone in social isolation, in turn and not least informed by lived experiences of solitary confinement. Another example is in the area of Article 8 of the European Convention on Human Rights, so stepping outside Article 3. In AP Garçon and Nicot against France, the court found that the requirement of sterilization, effectively, for a person to be allowed gender reassignment in France violated Article 8, and it did so acknowledging an absence of consensus on the subject, but taking very seriously that an essential aspect of the individual's intimate identity, not to say of their existence, was at stake. And in doing so, it heeded the deliberative outcomes again of bodies that focus on precisely this predicament faced by transgender persons. This openness also has a slightly more radical edge, perhaps, because the interpretation of human rights demands a constant process of alternating between the concrete and the general or abstract, between specification and abstraction, between context-sensitive assessment and going back to basics, so to speak. Because of this, there is the possibility that in considering a concrete issue, the court might also rethink intermediate principles and even the precise contours of the fundamentals, such as human dignity and precisely what it demands. And this has come up in cases such as Bouillied against Belgium, but also in the case concerning life imprisonment without parole, Winter, and the UK. So there is scope in this openness, that is, for, and I quote, breathtaking discovery and disruptive insight. I borrow these terms from an unexpected place, the Cambridge Vice-Chancellor's latest blog post against the marketization of universities. Now, I think that the openness and the dynamism that I advocate, but I don't think I'm alone in doing so, can be compatible and indeed be complemented by an attention to certainty, which prioritizes clarity and transparency in reasoning and the distillation of meaningful generalizable principles in the process of interpreting and applying convention rights. This is not least because it allows the doctrine to be better understood, but also to be better critiqued. So to conclude, the European Court of Human Rights, I think, cannot and ought not to strive for total certainty, and I don't think any legal actor can. But it is important to realize, I mean that in the sense of both discovery and fulfillment, to realize the value of certainty in the court's interpretation of the Convention. This value is both underpinned and delimited by the centrality of the person and by the object of the European Convention on Human Rights, which is to protect human rights, not to protect or appease contracting states. At the same time, and in view precisely of the centrality of the person in safeguarding their human rights, the European Court of Human Rights should be restless in the context of uncertainty about the concrete and abstract ways in which we can understand human rights and the correlative state wrongs. Before I finish, I might be allowed another minute. I just wanted to say I don't think I'm saying anything remarkably novel, and I may also well not be saying it particularly well. But I do want to close by maybe preempting and defending it briefly against one particular line of criticism from good faith supporters of the European Convention on Human Rights and the European Court of Human Rights. What I've said may be taken to be an idealistic stance on the European Court's role and may be denounced by pragmatic supporters of the European Convention and European Court as running counter to the hopes for the Human Rights Project's survival and what that might hinge on, and any version of the current reality or future of the European Convention and the European Court more specifically. But it seems to me that an alternative future, which sees through the mutation of the European Court of Human Rights function into the mere reproduction of popular preferences or realpolitik, or casts it as the subsidiary overseer of the dismantling or dilution of human rights safeguards, is considerably more threatening to the survival of human rights as we understand them. Thank you for listening.